So I guess the big question, what happens if I die and I don't have a will? I mean, what happens with my family? What happens there? What's the
Well, it's a problem. is the short answer. And sometimes the problem is reasonably easily fixed, and not so bad. And other times the problem really is a big problem. When someone dies without a will, there's they're called the Administration Act in Western Australia.
Okay.
And that's like it's a statutory will, it's a fallback provision. And in section 14.1 of the Administration Act, there's a table in there, and the table says, who gets what, basically. It says like, if you've got a wife, then this happens. If you've got, or a husband, if you've got a wife and husband but no kids, this happens. If you've got a husband and wife and kids, then this happens. And it goes all the way down to, a brother or sister, a parent, a child of a predeceased brother or sister. It goes all the way to nieces, nephews, and then right at the bottom it's got the state. Where, everyone goes, if I don't have a will, the state, the government's going to get my money. Well, only if you've literally got no family, no extended family, no will, is that going to happen. So, I think I've had one case in over 10 years where it was what they call a sheeted to the governor in council or chambers or something, under the older Sheet Act, and I had to apply and ask for the money back for some friend or something. I can't remember whether it worked or not, but it almost never gets to that. So, but the issue with that is, and probably talking about, it's not such a big issue if your estate's really small, and you've got these things like superannuation, you've got your joint tenancies with your bank accounts and your joint tenancies with your house. So like you might have spouses, the survivor might get the bank account. It's pretty straightforward.
Yeah.
Just take the death certificate into the bank, a piece of cake. But when you actually need to go to the court and get a court order to administer the estate, you've got no will, so you've got no executor appointed. And then you've got to say, well, who's going to be the most appropriate person to take on that role? And it's all the family members, basically, all the people that are entitled. And basically, this is where you start getting to problems, because to make that application, if you need to make an application, you actually need to contact and get the consent, or seek the consent of anyone that is also entitled to make the application. So if you've got like 4 or 5 family members, and it's always a drama when you've got families that don't get along, because you've got to then contact these people and say, well, your dad's died, or your mum's died, or your auntie's died, or whatever, and they just don't like each other. And sometimes there's a fight about who's going to be the legal representative of the estate and manage everything. So we have lots of fights about that. So that all of that can be avoided by doing a will. And
I'm sure there's a lot of people who would like to self-appoint themselves as executor, as opposed to the owner of the assets doing that.
Yeah. So
and that doesn't necessarily equate to the right person being the executor.
Oh yeah, you have to. This is the other thing is when you're talking about doing your will, you want to make sure that you've got exactly the right person in place. You've got you trust the person. They're in the jurisdiction, because it can cause problems if they're overseas or in another state. The court doesn't really like non-resident people. And then from a practical perspective, you've got this issue of signing forms, and so if you've got executors in other states, you're posting stuff back and forth, and the banks and everyone are still dealing with these stupid wet ink signatures, and they haven't quite twigged onto technology yet. But the administration one we were talking about before, they're like, what the biggest problem that I find with it is when you don't have a will is when there's kids involved. So a lot of cases we get, like the husband or the wife's died, they've got 2 or 3 young kids. Who's going to be the legal representative of the estate? Well, the kids are actually entitled because they're getting the estate, perhaps, and they can't apply to the court because they're young. And not only that, but the court then requires a special security bond, or like a surety's guarantee, or they might want a trust set up for the kids to protect the kids' interest before they give them the money. So you're doing all these legal documents and affidavits, and it's just a total. It's great. Like, it's great for lawyers, but it's sad. It honestly is. I've had heaps of examples where you've got, the mum is having to, of her own kids, get some third-party trustee involved or a guarantee involved just to manage a small amount of money, maybe $100,000 for these kids over their lifetime. It's like, come on, like the mum knows what's in the best interest of the kid, but you're just going to jump through all those hurdles. And there's a new, the Administration Act's being amended in the pipework for the last, gosh knows how long. But soon it's actually going to change, because at the moment the wife gets the household effects, first $50,000 and then the first 1/3, and then the balance, the 2/3 after, goes to the kids. There's an interest calculation in there as well. But the new legislation, the new Admin Act is going to change that, because the old one, which was a 1903 Act, I think, the first $50,000 was literally the equivalent of buying a house, or giving a house to the spouse. So now $50,000 is like nothing. So the new Act is actually going to give, I think, around $500,000, $517,000, and it's indexed every year to the spouse, and then the balance to the kids. But that's been in the, I think it's even past the upper house already. It's ready to be gazetted. So that's coming in the next, hopefully.
So